done enough damage, Dad. We don't need you here anymore." My son-in-law said it loud enough for the other 6 people in that conference room to hear. My daughter sat beside him, not looking at me. My attorney shifted in her chair. The mediator, a woman who'd spent 30 years watching families tear themselves apart, went very still. I had just turned 63. I had spent 41 years building Caldwell Precision Manufacturing from a 2-machine shop in a rented bay outside Columbus, Ohio, into a company that employed 214 people. I had signed the papers that morning transferring operational control to my son-in-law and daughter as part of what they had called a planned family succession. And then, while the ink was barely dry, my son-in-law slid a second set of documents across the table. A full buyout offer, my remaining shares, a non-compete clause stretching 5 years and 3 states, a clause requiring me to vacate my office within 30 days. "We think it's time for a clean break," my daughter said. She was using the voice she saved for difficult conversations, measured, rehearsed, the kind of voice that tells you the decision was made long before you walked into the room. I looked down at the number on the buyout sheet. It was low. Not insultingly so, but carefully so. Just high enough that refusing it would make me look greedy, just low enough that they knew I'd walk away diminished. I set the papers back on the table. I looked at my son-in-law. I looked at my daughter. And I said, "I'll need to think about this." My son-in-law's jaw tightened. He'd expected resistance or capitulation. What he didn't expect was calm. "There's not much to think about," he said. "This is a fair offer." "Then it'll still be fair next week," I replied. I gathered my copies, thanked the mediator, nodded to my attorney, and walked out. The hallway was empty. The building was one of those glass and steel office parks that all looked the same from the outside. Could be anywhere in America, could be any Tuesday. I stood at the window at the end of the hall and watched a delivery driver cross the parking lot below. He had a hand truck stacked with boxes. He was moving fast, purposeful. I'd built something for 41 years. And the people I'd built it for had just handed me a document that told me what they thought I was worth. My phone buzzed. Text from my attorney. "Call me when you're in your car." I walked to the elevator. Her name was Patricia, and she'd been my attorney for 19 years. She didn't do sentimentality, which was part of why I'd kept her. "Did you read the IP annex?" she asked before I'd finished saying hello. I skimmed it. "Don't skim it. Read it tonight. All of it." "Why?" "Because the assignment language in Section 4 assumes you already transferred the core process patents to the company. Did you?" I pulled out of the parking lot and sat at the light. "No," I said slowly. "I never did." There was a pause on her end. "When you founded Caldwell Precision, the original patents were filed under your name personally, standard practice for a sole proprietor. The question is whether subsequent licensing agreements transferred beneficial ownership." "They didn't," I said. "I remember the conversation. The attorney at the time said it wasn't necessary for operational purposes." "Then those patents are still yours." I drove in silence for a moment. How many processes are covered? "I'm looking at the original filings right now. 7 patents. The core thermal bonding process, the alignment calibration method, 2 of the finishing protocols." I knew those numbers without thinking. The thermos bonding process alone was what had made Caldwell Precision the preferred vendor for 4 regional aerospace contractors. Without it, the company was a competent machine shop. With it, it was something genuinely rare. "Does my son-in-law know?" I asked. "Based on the language in this buyout offer," Patricia said, "I would say no. They assumed everything transferred when you signed operational control." "It didn't." "No," she said. "It didn't." I pulled into a gas station on Route 40 and parked, not because I needed gas, because I needed to stop moving. "What are my options?" I asked. "Many," Patricia said, "but let's talk in the morning. Get some sleep first." I didn't sleep much. I'd started Caldwell Precision in 1983 with money borrowed from my father-in-law, my first wife's father, not my current daughter's grandfather, and a lease on 900 square feet in a converted warehouse. I ran the machines myself for the first 4 years, payroll out of my personal account more than once. My wife at the time kept the books on Saturday mornings at the kitchen table while our daughters sat in a playpen 6 feet away. That daughter was the one sitting across from me in that conference room. Her mother and I divorced when she was 11. It wasn't cruel, just finished. We'd grown into different people. She remarried eventually. So did I. Briefly, then not. My daughter and I had rebuilt things slowly over the years. By the time she was in her late 20s, we had something real, not exactly easy, but honest. When she met her husband and told me he had an MBA and wanted to work in manufacturing, I thought it was a chance. I brought him in as operations director 8 years ago. He was sharp. He learned fast. He had good instincts with vendors and was better than me at managing personnel conflicts. I told him so. I meant it. What I didn't see, or chose not to see, was the way the company started to reorganize itself around his presence. Small things at first. His name on proposals, where mine used to be. Introductions at trade shows, where I became the founder, past tense, before I'd agreed to be in the past. When he and my daughter first raised the succession conversation 3 years ago, I thought it was reasonable. I was 60. The industry was changing. Fresh eyes had value. We structured a 5-year transition plan. I agreed to step back gradually, to mentor, to consult. The transition took 2 years, not 5. The buyout offer came 8 months after I'd signed over operational control. In that conference room, when my son-in-law said, "You've done enough damage," he meant the last quarter's revenue dip, which he blamed on decisions I'd made 18 months earlier. I had a different read on the numbers, but that was the story he'd been telling the board, and by then the board was mostly his. I thought about all of this sitting in that gas station parking lot. Then I drove home. Patricia and I met at her office at 7:30 the next morning. She had the patent filings printed and sorted. She had a yellow legal pad with notes in her small, precise handwriting. "Here's where we stand," she said, setting a coffee in front of me. "You personally own 7 active patents. 2 expire within 18 months and have limited practical value at this point. The other 5 are current, enforceable, and represent what I would estimate as the core operational advantage of Caldwell Precision in 3 of its 4 primary contract categories." "The aerospace work," I said. "Yes, and the medical components division." That division had been my idea 3 years ago. My son-in-law had resisted it initially, said the margins were too thin, the compliance overhead too heavy. I'd pushed. It was now 22% of annual revenue. "If I don't transfer those patents," I said, "what happens?" Patricia folded her hands on the table. "The company can continue operating processes covered by those patents only with your consent. Currently, they have an informal license by virtue of your role as founder and controlling partner. You signed over operational control. You did not sign over IP rights. Those are legally distinct. And if I withdraw consent? That would trigger a licensing negotiation, or litigation, or both. I don't want to litigate against my daughter." "I know," Patricia said. "But you also don't have to accept a buyout that values you at roughly 40 cents on the dollar." I looked at the patent filings. 41 years of problem solving, documented in government filings, still under my name because of a paperwork decision nobody thought to revisit. "What would a fair number look like?" I asked. Patricia had a figure ready. She'd done the work the night before. It was more than double what they'd offered. My daughter called that afternoon. Her voice was different from the conference room, less rehearsed. "Dad, can we talk?" "Of course." Not with the attorneys, just us. We met at a diner I'd been going to since before she was born. Minor booths, coffee that came in heavy ceramic mugs, a lunch counter that still had spinning stools. She ordered a grilled cheese. I had soup. Felt like the right kind of meal for whatever this conversation was going to be. "He thinks you're being difficult," she said. "He may be right," I said. She looked up. "You're not going to fight me on the offer." "I'm not fighting anyone. I'm making sure the offer reflects what I'm actually selling." She turned her coffee mug slowly. "He says you never transferred the patents." "That's correct." "He says that was intentional." I considered that for a moment. "It wasn't," I said. "But I'm not going to pretend it doesn't matter now." She was quiet for a while. Outside the window, a school bus rolled past. It was the same route I used to drive her on, 20-some years ago, before she'd moved across town with her mother. "I didn't know it would go this way," she said. It was the closest thing to an apology she'd offered. "I know," I said. "He's not a bad person, Dad. I didn't say he was. He needed to feel like it was his. You know how he is. I did know. That was the problem. And also, in a way, the explanation. He needed the company to be his own story, not the continuation of mine. I understood the feeling. I'd felt it myself once, borrowing money from my first father-in-law, trying to prove the business was mine and not a favor. What do you want to happen? I asked her. She looked at me for a long moment. I want you to be okay, she said, and I want the company to survive. Those aren't mutually exclusive, I said. He thinks they are. I let that sit. Tell him I'll have a counteroffer on Monday, I said. I spend the weekend at my workbench in the garage. I still machine things by hand sometimes, not for any business reason, just because I'd done it for 40 years and my hands knew how. There's a particular kind of thinking you can only do when your hands are busy with something physical and exact. I thought about what I actually wanted. Not revenge. I want to be clear about that. When you're 63 and you buried one business partner and outlasted two economic crashes, revenge starts to look like a waste of a Tuesday. What I wanted was to not be erased, to not have the second half of my working life quietly annexed and rebranded as someone else's foundation. My son-in-law was talented. The company would likely survive under him. But survival wasn't the same as acknowledgement. On Sunday afternoon, my old plant manager called. He'd stayed on through the transition, but his voice had that particular flatness of a man who was watching something he cared about go sideways. There's talk on the floor, he said, that you're gone for good. Not decided yet, I said. The Hargrove account is asking questions. Hargrove Aerospace was our largest single client. We'd had a relationship for 16 years. The contact there was a man who'd started as a procurement analyst and worked his way up to VP of supply chain. He knew my name personally. He'd toured our facility twice. They want to know if the thermal bonding process is still going to be maintained at current spec. Who are they talking to? I asked. They've been directed to your son-in-law. And he told them the process is company property and nothing's changing. I set down the part I'd been holding. Call Hargrove's VP tomorrow. Don't tell them anything specific. Just let him know I'll reach out personally. You sure? Yes. Monday morning I had Patricia send the counteroffer. The number was what it should have been. The terms included a 5-year licensing agreement for the core patents, with royalty rates tied to contract volume. It included my name on the company's founding documentation, not ceremonial, structural. It included a consulting arrangement, optional at my discretion, for a period not to exceed 3 years. My son-in-law called before noon. This is unreasonable, he said. His voice had the clicked quality of a man who expected to win arguments quickly. It's accurate, I said. You're threatening the company's operations. I own intellectual property that is central to the company's operations, I said. That's not a threat, it's a fact. You built this for your daughter. I paused at that. I built this for 41 years before your daughter knew what a machine shop was, I said. I wanted to continue. I'm not trying to take it apart. Then accept the original offer. That offer doesn't reflect the value of what I'm transferring, I said. When it does, I'll sign. He hung up. An hour later, Hargrove's VP called me directly. He didn't open with pleasantries. I need to understand the ownership of your thermal bonding process, he said. Our compliance team is flagging it. The process is covered by patents in my personal name, I said. No licensing transfer has occurred. Any ongoing use by Caldwell Precision is subject to renegotiation. Silence. That's not what we were told. I know, I said. I wanted to make sure you had accurate information. He asked 3 more questions. I answered them carefully and honestly. Before he hung up, he said, We signed with you, not the company name. You know that. I did know that. I'd known it for 16 years. The emergency meeting happened on a Thursday. I wasn't invited. Patricia attended as my representative. She called me from the parking garage afterward, before she'd even gotten to her car. 2 board members asked to see the original patent filings, she said. Your son-in-law said the patents transferred automatically with operational control. That claim did not survive contact with the actual documents. How did my daughter handle it? She was quiet most of the meeting. And at the end, Patricia paused. She asked for a recess, came back and said she wanted to explore a revised structure. I sat back in my chair. They're not discussing litigation, Patricia continued. Nobody wants that, but they understand the leverage position. Hargrove's inquiry rattled them more than anything else. Good. There may be an offer coming. Better terms. Let them draft it, I said. Don't rush them. My daughter came to my house on a Saturday morning unannounced. I was in the backyard. She let herself in through the side gate the way she used to when she was a teenager. Stood by the fence for a moment, watching me work. I owe you an apology, she said. I set down my tool. Okay. Not for the succession. I still think that was right. But for the way it happened. She crossed the yard and sat down on the old bench I'd built when she was in elementary school, the one I kept refinishing every few years. He convinced me it needed to be clean, that any overlap would undermine his authority. It would have complicated things, I said. That's not the same as undermining. She nodded slowly. I let him do the talking because I didn't want to have the conversation myself. I recognized the honesty in that. It wasn't easy for her. She'd always been more like me than either of us wanted to admit, better at building things than explaining them. What do you need from me? I asked. I need you not to blow this up, she said, not out of anger. I'm not angry, I said, and I meant it. I was disappointed. Those feel the same from the outside sometimes, but they're different on the inside. The board wants to make a formal offer, she said. Licensing structure, revised buyout, your name stays on the founding documents. Patricia told me, will you consider it? I've been considering it, I said. That's all I'd been doing. We sat for a while without talking. A neighbor's lawnmower started up 2 houses down. The morning light was doing what it does in Ohio in early October, cutting sideways through the tree line, making everything look like a photograph of itself. I never needed the title, I told her. I needed to know it mattered. What I did. It mattered, she said quietly. It still does. I know, I said. Now. The revised offer came the following Tuesday. Patricia walked me through it for an hour and a half. It was structured differently. A phased licensing agreement, an adjusted buyout that reflected actual IP value, a formal acknowledgement in the company's articles of amendment that the founding patents remained under licensing from me personally, not transferred. It also included a consulting arrangement, 6 months, renewable at my discretion. I read everything twice. I signed it on a Wednesday afternoon. No ceremony, no handshake across a conference table. I signed at Patricia's office, she notarized it, and that was that. My son-in-law sent a text 20 minutes after the paperwork was filed, 2 sentences. Glad we could reach resolution. Looking forward to the partnership. I didn't respond immediately. I set the phone down and drove home the long way, out past the original facility on the east side of Columbus, the one I'd outgrown in 1991. There's a brake shop in that building now. Different sign, same bones. You can still see where we'd mounted the original ventilation unit above the bay door if you know where to look. I looked. Then I drove home. That was 8 months ago. The consulting arrangement renewed once. My son-in-law and I have not become close, but we become functional. He asks for my read on contract language more than he lets on. I give it without commentary. That's the agreement, unspoken. My daughter calls on Sunday evenings, not always about business, sometimes just to talk. We're still figuring out what we are to each other at this stage. Not the father and daughter we were when she was young. Not the colleagues we tried to be during the transition years. Something else still being defined. The Hargrove relationship held. The thermal bonding process continues under the licensing terms. 2 of the other patents have generated modest royalty income. Not life-changing money at this point, but consistent. And more than that, an acknowledgement in dollars of what was actually mine. I still go out to the garage on weekend mornings. I still machine parts by hand sometimes. The work is quiet and exact and doesn't require anyone's approval to be done well. 63 years old, 41 years of building something. And what I learned in that conference room when my son-in-law slid a piece of paper across the table is that knowing your own value precisely, not roughly, not emotionally, but with documentation and patience, is the only thing that makes you genuinely hard to erase. He said I'd done enough damage. He was wrong about what I'd done, but he wasn't entirely wrong about what was coming. I've thought a lot about that conference room, the way the paper slid across the table, the way my son-in-law said, "You've done enough damage," like it was a verdict that had already been appealed and denied. I've thought about my daughter sitting beside him, not looking at me, and how that particular kind of silence, the one from someone who knows you well enough to know they're hurting you, is different from any other kind. What I keep coming back to isn't the patents. It isn't the leverage or the licensing terms or the phone call from Hargrove's VP. What I keep coming back to is a simpler question. Why was I still standing when it was over? I don't think it was luck. I think it was 41 years of doing the work honestly. Not perfectly. I made mistakes with the company, made mistakes as a father, made mistakes in both my marriages. But I never misrepresented what I'd built. I never took credit for what belonged to someone else, and I never signed away what was legitimately mine just to avoid a difficult conversation. That's not a virtue I planned. It's just what I knew how to do. And it turned out that doing right by the work, filing the patents correctly, structuring the agreements carefully, treating client relationships like they were worth protecting, meant that when someone tried to tell me I was worth less than I was, the paperwork disagreed. There's a version of this story where I take the original offer and spend the rest of my life quietly bitter about it. I almost did. Not because I didn't see the problem, but because fighting your own daughter in a legal proceeding requires a particular kind of resolve that doesn't come naturally to most fathers. You have to be willing to hold a line even when holding it costs you something that matters more than money. That's hard. It was the hardest part of all of it. But I'd learned something in 4 decades of running a manufacturing business. The moment you accept a number that doesn't reflect the truth, you're not just settling a transaction, you're agreeing to a false account of your own life. My son-in-law is not a villain. I want to be clear about that, the same way I was clear with my daughter in that diner. He's a capable man who needed the story to start with him. I understand that hunger. I felt it myself at 30. What he hadn't yet learned, and maybe has started to, I can't say for certain, is that you can't build something real on an erasure. You can rename it, you can rebrand it, but the foundation is still what it always was, and the foundation knows. What got me through wasn't anger. Anger is loud, and it burns fast, and it makes you say things in conference rooms that follow you for years. What got me through was something quieter, the discipline to wait, to read the documents, to call Patricia before I said a word to anyone else, to let the facts do the work that emotions would have ruined. And underneath that, something I didn't fully understand until I was sitting in my garage on that Sunday, machining parts for no reason except that my hands knew how. I still believed the work mattered. Not the title, not the office, the actual work, the thermal bonding process that 16 years of aerospace contracts had validated, the medical components division I'd pushed for when nobody else thought it was worth the trouble, the people who'd stayed because they trusted what we were building. That belief, in the work, in the honest accounting of it, in the willingness to defend it without theatrics, turned out to be the only leverage that mattered. If someone has handed you a number that doesn't reflect your truth, don't sign it in a hurry. Read the documents. Know what's yours. Be patient enough to let the facts speak before you do. The work already knows what it's worth. Sometimes you just have to give it room to say so.